I think it is clear to believe in the power of ideas.
Fresh thinking of the Manhattan Institute.
As Jim has indicated, criminal law has strayed very far from its historical roots. Many statutes have punished those whose acts are wrongful only by virtue of legislative determination. And the distortion of the classical criminal law has arisen for a variety of reasons, some of which may have been accompanied by benign motives. But for example, the Enron scandal and similar acts of intentional corporate fraud have led to overly broad proposals that may trap honest but unsuspecting executives. So however it's arrived at, the unintended consequences is to trap CEOs and business executives and alter their decisions. All of you are familiar, no doubt, with what has happened to Arthur Andersen in the wake of the Enron scandals. A venerable firm of many years was destroyed because it could not withstand the allegations that were impugned to the entire firm, even though it was only the Houston partners that were actually under indictment. Also, perhaps the most egregious example, that in the wake of the tech bubble, then Attorney General Eliot Spitzer identified a number of insurance companies and mutual fund companies, banks and others. In fact, he targeted Merrill Lynch with allegations that they were selling inflated shares to firms for which they were getting investment banking fees, and they extracted $100 million fines paid to the government, not to the investors. But it's not just those highlighted examples. I mean, there were companies in the Midwest, like a healthcare firm called WellCare, which had visited upon itself federal investigators and lost 3/4 of its market value, even though the investigators never even announced why they were there, what they were doing. So this has a number of ramifications for business, not the least of which are the decision-making and the consequences for the economy. So I'm going to ask my friend Dick, how did we get into this mess?
Start from the beginning, eh? Well, I have to acknowledge I've worked both sides of the streets on this issue. I've been a prosecutor and I've been a defense lawyer for corporations who have tangled with the U.S. Department of Justice. So I think I have a somewhat balanced view of how we got here and what we might do to reduce some of the pressure on some of the mainsprings of our free enterprise system. I think the thing that's important when you look at corporate liability, you recognize that corporations are artificial entities. They're not like the rest of us in our daily lives. They have powers and they acquire certain characteristics only from the laws that create them. And that makes them, in the view of those disposed against them, fair game for most anything that comes along. So about 100 years ago, the Supreme Court of the United States was faced with the question of whether or not a corporation as such had any liability under the criminal laws for activities that it undertook. Up to that time, as part of the common law, there was a doctrine that lawyers will recognize, and to others I apologize, the doctrine of respondeat superior. That is to say that when an individual worked for you and was acting in your interest and did something wrong, and there was a question of liability, it was not just that person, it was you that had to answer for any harm that was done. This was, in 1909, by the Supreme Court, transported magically into the criminal area as well. And since that time, we've had a developing field of criminal liability on the corporate side that I think far outstretches what anybody would have expected at the time. One of the reasons, of course, is that corporations are thought to be fair game for populist agitators and for the Ralph Naders and Eliot Spitzers of this world, who see an easy target to promote their own personal interests. But what you really have here is a three-part play. While it was the court that originally established the status of corporate liability under the criminal laws, they were aided and abetted, as usual, by the other two branches of government. That is to say that the legislature, the Congress of the United States in particular, embarked on a effort to proliferate criminal liability across the board in every single field in which corporations are active. Part of the progressive movement in the early 20th century, but continuing to this day through Sarbanes-Oxley. That is the notion of creating new liabilities for corporations. And I think that probably the main reason is the unquenchable desire of members of the Congress to do something. They wake up in the morning, they look at the papers and see the headlines or the top of the morning news and see something wrong and they want to do something. Well, what that's resulted in is a proliferation of now over 4,500 separate criminal laws, many of which, if not most of which, apply to corporations. So the courts created the rights, the Congress proliferated, and then the executive branch. And you've gotten, in recent years in particular, a very activist group within the Department of Justice that has sought to expand the presence of the federal government in recognizing wrong on the part of corporations. Beginning with, unfortunately, our now Attorney General, Eric Holder, in 1999, and when he was a Deputy Attorney General, and continuing through 4 other Republican Deputy Attorneys General, guidelines have been set down for the prosecution of corporations in particular situations. Now, let me just take a step back here and remind you that if criminal acts are committed by individuals in the employ of a corporation or not, they have to answer to the criminal law for the consequences. But what's new and different here, of course, is the expansion of that individual liability to corporate liability, as was pointed out in the case of the Arthur Andersen situation, a death sentence for that venerable firm because of the attribution of criminal conduct to the entity itself rather than just the individuals. More about that later on, but I think that's about as quick a history as I can give of how we got to where we are today.
Ken, you've been on the firing line of this. You've actually faced it firsthand. Tell us your own experience of this and how you reacted to it. What were the circumstances? And
let me first correct the very generous and gracious introduction. And I do this because I think it's important. I'm not a self-made man, and I've never met a self-made man. All of us, one way or another, are dependent on each other in many different ways. And I'd like to think I was self-made, but in the cold light of day, I had an awful lot of people helping me along the way, so I think they deserve as much of the credit as I do. But let me address this issue. I think the biggest mistake we make is to put a party label on it, because I don't think it takes much reminding that the prosecution of Arthur Andersen was under a Republican administration. Everybody's hands are dirty, and I believe this in a very aggressive way. I think that the so-called criminalization of corporate behavior is one more example of self-interest. The lawyers that become high-priced defenders, I don't mean to give you tight shoes, Governor, but the lawyers, and I'm not a lawyer, so I guess I can have a field day with this one. The lawyers who get very high fees because people go to them on the basis that they understand how the other side works. I think it's more than a coincidence when you look at the number of great names. And there's one lawyer in particular that I have enormous respect for because he didn't do it. And that's our Chancellor of Education here in New York, Joel Klein. He left. He was the head of the antitrust division of the Justice Department, and he's committed the rest of his life to helping kids get a good education in the city. And I might tell you, he's winning. I don't know how you deal with this self-interest there. And then you have our politicians who know that headlines, whether justified or not, are very helpful at the poll. But the Arthur Anderson thing to me is one of the, and I believe, too late of course, but